the NYLESA Podcast.
Supporting UN spouses in New York.
Welcome to the 5th episode of the NYLESA Podcast. My name is Zain Dudar.
And I'm Martin Arrow.
In this episode, we are going to talk about immigration options beyond our current G4 visa status.
Yes, in this episode we will learn what options do we have if you want to remain in the US after you or your spouse separate from the UN.
And we will also talk about the US immigration status for children of UN workers and UN retirees.
That's right, and as we always do in our podcast, we went to talk to an expert on the subject.
Yes, and inspired by the fact that today we are talking to a lawyer, we would like to take this opportunity to say that the different experts we interview for our podcast express their own opinions and points of view, and that neither us nor NYLESA endorses or recommends their services.
Exactly, and on the other hand, we really appreciate the fact that these experts take time from their busy agendas to meet with us and answer our questions.
Okay. Having said that, for today's episode, we interviewed Suneeta Dewan. She is an immigration lawyer with almost 15 years' experience working with UN clients.
And our first question to Suneeta was, what are the most frequent cases in your practice regarding UN-related clients?
The most important cases are when people are ready to leave the UN system, but they want to remain in the US, and they're looking for permanent resident status. So the easiest way is for those who retire and have put in 15 years with the UN at headquarters, being their employer for 15 years, they are eligible to file for permanent resident status. Now, what is important here is that the person could have left the country for brief periods during those 15 years, for short assignments, home leave, travel, etc. And that doesn't take away from the 15 years. But what will take away from the 15 years is long-term assignments. So if you're on a mission for, let's say, 3 years to the Congo or somewhere, you then will need 18 years to be eligible. The thing to note here is that the 15 years need not be consecutive. It's cumulative. A lot of staff members come to me without that knowledge. They don't realize that they may have put in 2 years in the 80s, then they come back in the 90s, and they don't realize that those 2 years count. They do actually count. So that's something to keep in mind. Also, a really important factor in all of this is that in the last 7 years, the staff member should have been physically present. It's a requirement that the person be physically present for 3.5 of those 7 years. Again, it's cumulative, it's not consecutive. Because not often, but I have had on occasion people in tears because they didn't realize that and went on a long-term assignment during those last 7 years and missed out because they didn't make the physical presence test for the eligibility for the green card. So that's an important one for them to know.
And is the eligibility the same for the employee and the spouse?
The spouse gets on the application, the spouse gets on the petition along with the staff member. So the staff member is filing what's known as an I-360 as a self-petitioner, and alongside that, adjusting the status from G4 to permanent resident. So in that adjustment application, the spouse gets on as a derivative. And even if the spouse does not meet the 15-year requirement, the spouse will still be eligible for a green card on the basis of the eligibility of the primary. Now, sometimes people come to me and say, well, my spouse, the primary, worked for 7 years, and I have worked for 8 years. So combined, we have the 15 years. Is that going to work? No, that's not going to work. So you have to have been the primary for 15 years.
And provided the primary has more than 15 years with the UN system, the spouse can apply regardless of the number of years they have been married, or they need to be married for a minimum number of years?
The spouse could be a spouse for one day, as long as it's a legitimate marriage. The shorter the duration of the marriage, the more the officer reviewing the application is likely to, look into it. The scrutiny is likely to be more intense if the marriage is of a shorter duration.
And once you get your permanent resident status, do you need to stay in the US?
Okay, now that's a wonderful question for UN staff because they're constantly getting themselves into trouble with this. Here's what they need to know. Once they have permanent resident status, the US would like them to be quote-unquote permanent residents of the United States. Not that they're getting the green card that they will put in their pockets and live in Spain or elsewhere. If they spend more than 180 consecutive days outside the country, after having got their permanent resident status, there is a presumption in the law that they've abandoned their residence. Now, that presumption can be rebutted, so if they fall ill, meet with an accident, have an elderly parent they need to care for or something, they can rebut it. But it can't be a pattern where they're spending 180 or more days consecutively outside the US. And if they spend more than a year out of the US, they will have abandoned their residence. So if they know ahead of time that they're likely to spend a longer period, they can get a travel document, what is also known as a re-entry permit, which will allow them to spend up to 2 years outside the US and yet preserve their resident status.
And they have to apply prior to going out?
They have to apply prior to going out. They have to be physically in the US when they apply. And there's a biometrics requirement which could take up to 3 weeks. So when they plan on filing the re-entry permit, they should plan on either being here, physically present for 3 to 4 weeks, because that's how long the process will take. Or if they leave, they need to be able to come back for biometrics, because biometrics will not be done at a consulate or embassy abroad.
Is it the same if you become a US citizen?
Once you become a US citizen, strangely, it allows you more freedom than the green card does, because then you can actually live outside the US.
And after how many years can you apply for a US citizenship? Does it depend which country are you from?
No, it's not country specific at all. But that's an excellent question, and I'll tell you why. You normally need 5 years as a resident, as a green card holder, before you're eligible. And there's a window of 3 months, so it's 3 months prior to the 5 years that you can file for your citizenship. However, if you're married to a US citizen, you only require 3 years. Now, if you are married to a US citizen, but get a green card as a retiree, almost everyone at the UN will tell you that you need 5 years. No, you don't. You need 3 years. Because even if you get your green card as a retiree, the fact that you're married to a US citizen will allow you to naturalize in 3 years and not have to wait 5 years.
Okay. And can you obtain a green card via your child, assuming your child already has one?
So the route to the green card via the child is a good alternative for those who are not eligible as retirees. So if someone hasn't met the 15-year requirement or chooses to leave the UN prior to retirement, what they could do is have that child that got the green card naturalize and as a US citizen file for the parent. If the parent is in the US, the family-based petition or the I-130 is filed concurrently with the adjustment of status, and so the parent can remain here, adjust status from G4 to permanent residence. If the parent chooses to be outside, because work takes them out or they have other reasons to be outside, they can file the I-130 petition, the family-based petition, and process the second part at the consulate of the home country or the country that they are visiting or working in. So the citizen-child route is a good alternative because a lot of UN family members do have children who've got their green cards by virtue of being here in G4 derivative status between the ages of 5 and 21. And the child is deemed 21 until he or she turns 22. So up until the second birthday, they have to have had 7 years in G4 derivative status. And again, it's 7 cumulative, not consecutive.
Any advice on this matter?
Please do not send your child to a boarding school overseas, because if you do, that time will be deducted, because that is a time that the child is not here. Even though the child may be going in and out of the country in G4 status, that time will be deducted. So I've had family members lose that opportunity to get green cards for their children. They're very upset, and they regret the fact that no one informed them of this beforehand.
Another common situation for our members is to have a child while they're living here in the US. Does having a US citizen child have any implications regarding the future immigration status of the parents?
It's really unfortunate, because the US citizen child cannot confer benefits to the parent the way the green card child can. Because there's something known as the N8 visa, which is an obscure little thing. Are you familiar with it at all?
No.
So if you have a child who's got a green card and is still a minor, and one parent is going to, let's say, a non-family station, and let's say it's the father who's being relocated, and the mother wishes to remain in the US with the minor child because the minor child is in school here. So the fact that the child got the green card through the UN system allows the parent to get the N8 visa, which allows the parent to also work while in the US. So parent gets to stay in the US and work in the US in N8 status because the child has a green card. But the same child, if he or she were born here and is a US citizen, cannot confer the N8 benefit to the parent. What the US citizen child can do, though, is once he or she turns 21, sponsor the parent for a green card.
And there is no minimum number of years, right? Once the child turns 21, he or she can ask for you.
The child can sponsor, yes. The only reason living here becomes important is there's something known as an Affidavit of Support. And the Affidavit of Support does two things. One is it supports for immigration purposes, and the other is the financial support. Now, if the child is living in the US, the source of income is in the US and is therefore a reliable, predictable source of income. And you provide tax returns, you provide pay stubs and W-2s and all of those to establish that the child can actually support the parent. If the child is overseas, that becomes a bit of a problem, and you may need, depending on the situation, you may need a co-sponsor who is either a green card holder or a citizen for the financial aspect of it. Immigration will still be done by the child.
And do we as G4 visa holders have any advantage when applying for a green card?
So there certainly is an advantage to being a G4 holder. Not the same with G1s and others, but G4, yes, for sure. For that matter, when we go for interviews, for green card interviews, I rarely accompany UN people because those filing through the UN system don't usually get called for an interview. But occasionally, I've had maybe a handful over 15 years that were called, and I accompany them. I see that interview is pretty routine. They're very, very liberal, very lax in the way they review the case as compared to how they review other cases.
I assume all the things we are talking about today apply also for same-sex marriages, right?
Yes, the same-sex marriage couples have the same rights, privileges, and duties as heterosexual marriages. I haven't seen any difference in adjudication.
Okay, and what happens if someone with a G4 visa gets in trouble with the law? How does this affect his or her immigration status?
Yes, that happens where there are two issues that are quite common. One is a previous visa overstay. So if you have a visa overstay and then you get into G4 status by virtue of a job opportunity at the UN, the visa overstay gets deferred. The issue gets deferred until after you get off the G4, and then they'll deal with you. The other issue is, minor criminal issues with the law. Very often there's a charge of shoplifting or something like that. Now, that can hinder the green card process. So what we have the person do is go to the court where they were charged with the offense and get what is known as a final letter of disposition. And depending on what that is, usually a criminal defense attorney will have, pled to something less. And depending on what that is, we will then, file the green card and find ways to have that person be admissible, because a crime of moral turpitude, and theft is a crime of moral turpitude, is something that makes one inadmissible. So the criminal aspect of it must be dealt with and not, thrown under the rug, which I've had a couple of people do to me. Is, we go to the interview and then find out that, oh gosh, he didn't reveal that this is what had happened because he thought it would just somehow go away. But it doesn't go away. So deal with it. Let's find the solution before filing and before being interviewed.
Now, if my employer is willing to hire me with a H-1B visa and I'm a G4 dependent, can I change from G4 to H-1B?
No, the UN does not allow that. The UN would like the family member to remain in G4 status with the EAD and work on the EAD. A lot of attorneys don't know this, so they go ahead and file an H1 or an O1. I have to admit I did that the first time and found out that it's not an option.
Okay, what happens if a UN spouse gets divorced? Can he or she stay in the country as a G4 visa holder?
No, the divorced spouse has to find his or her independent status. Now, at that point, they can exit the system and get a visa, whether it's a F1 student visa or an H1 work visa or an E2 visa, which is a very good option. People are absolutely ignorant about this wonderful opportunity called the E2. So let's say somebody wants to leave the system before retirement or doesn't make the 15 years. There are treaty countries that are eligible for the investor E2 status. The E2 is a non-immigrant visa. It doesn't require the mandatory $500,000 or $1 million investment that the EB5 requires. This only requires an amount that is considered reasonable for the investment. So if it's a hairdressing salon, let's say $100,000. If it's a restaurant, let's say $100,000. If it's a gas station, maybe $250,000. So I have a UN staff, a few of them actually, that own gas stations because they didn't make the 15-year mark, and they wanted to remain in the country. So, and you can switch from one business to another. So one of them, for example, had a gas station for a number of years, and she's now looking to buy a different type of business. So the business allows you to work here and conduct that business, and as long as the person's doing well and the business is doing well, there's no mandatory requirement for a certain number of employees. It's just that the business has to be more than marginal. The business cannot just provide a salary to the person. It has to be a little more than that. So let's say 1 or 2 employees and some profit in the business, and a person can stay here as long as they wish.
And you said this is for a select number of countries, correct?
There are certain countries that qualify, so you have to look at the E2 list to see if your country is a treaty country.
Okay, now I've heard that if you are considered as an extraordinary person or something like that, you can apply for resident status. Is that right?
Oh, yes. So that's another thing that I have done, and a number of cases, as a matter of fact, where The higher level, usually it's a P5 and over, D1s, D2s, that are extraordinary in the field that they're working in. So we file an Eb1 Self Petition as a person of extraordinary ability. Whether it's an economist, a UNDP economist has been done through our firm, and a number of others. They will also self-petition, just as a retiree would self-petition. But here you have to prove that you're a person of extraordinary ability. And that's a very nice path to the green card because you don't need an employer sponsor. You essentially self-petition.
I know someone that has an O1 visa, and she's also a person of extraordinary ability. What is the difference between Ab1 and O1?
The O1 is another option that I've used very often, where a person leaves, doesn't quite make the cut for the Eb1, because the Eb1 is a person of extraordinary ability, but what you're doing is you're filing for permanent resident status, which is a green card, which is a much higher threshold in terms of evidence than an O1, which is a person of extraordinary ability, but for a non-immigrant status. So even though when you go online and you look at the requirements look very similar, but the O1 has a lower threshold and therefore easier to satisfy, but the O1 requires an employer sponsor, whereas the Eb1 does not.
And do you need to renew the O1 from time to time?
The O1 has to be renewed, and again, it can be renewed indefinitely. There's no finite duration like the H1 has the 6 years. The O1 does not.
Okay, and what other options does someone who leaves the UN system have?
So the I visa is another option for those who want to exit the G system or have reached a point of retirement but don't qualify for the green card, where they can have a foreign press organization, provided they're journalists. The foreign organization sponsor them for an I visa, and they can work here as representatives of that organization.
It seems that there are many options, right? In your opinion, what are the best ones for someone who doesn't have the required 15 years in the UN?
The O visa is really, I think, one of the best, and the E2.
Excellent. Thanks, Suneeta. And lastly, if one of our members needs more information, how can they reach out to you?
So my name again is Suneeta Dewan, and I am a partner in New York for a firm called Chugh LLP. Our phone number is 212-629-8899, and please feel free to ask for me. I do have associate attorneys and paralegal staff. We do speak a number of different languages. Feel free to call and feel comfortable to speak in Spanish, French, English, Tagalog, Hindi, and a couple of other languages. So we welcome UN staff. We've always enjoyed working with the UN community. So we look forward to meeting more of you.
Okay, thank you very much, Suneeta, for your time and valuable contributions.
You're welcome. Thank you. It's been a pleasure.
And with these, we have arrived to the end of this episode.
Yes, we really hope you like it.
If you don't want to miss out on our future episodes, please go to our website, NYLESA.org, and subscribe to this podcast. As you already know, it's completely free and it would help us a lot.
Thanks for listening to the NYLESA Podcast.
For more information about our association, please visit NYLESA.org.
Or follow us on facebook.com/nylesa.org.
If you want to suggest a topic for this podcast, please send us an email to podcast@nylesa.org. The NYLESA Podcast.
Supporting UN spouses in New York.